Good afternoon, everyone. I'm Sophie Richard, counsel of the Knowledge Management Tax team of Arendt. Thank you for joining us today for discussions on transfer pricing and key takeaways from recent case law. For these discussions, we have two great speakers. First, Alexandre Maschiella, who is Senior Associate in the Tax Law Practice of Arendt. He has several years of experience in transfer pricing, focusing on financial transactions, asset management, and litigation. Welcome, Alexandre.
Thank you.
And we have Alain Goebel, who is a partner in the tax law practice of Arendt. He has more than 20 years of experience, and he advises clients on the tax and transfer pricing aspect of Luxembourg and cross-border transactions. Welcome, Alain.
Thank you.
Before we get started, the usual housekeeping rules. So first, we have a Q&A section in the WebEx where you can ask your questions, and the speakers will address them after the presentation. And if you have technical issues, please use the chat box also in the WebEx. So now, Alain, Alexandre, I'm very happy that you will share with us your views and analysis regarding first the decision of the Court of Justice of the EU in the well-known case of alleged state aid against FIAT, and second, your analysis regarding the recent Luxembourg Administrative Tribunal decision on the recharacterisation of an interest-free loan as equity.
Hello and welcome. For the first part of today's webinar, we found it appropriate to start with the European dimension and the final decision of the European Court of Justice on the appeal submitted in relation to the FIAT case. This case has been issued recently, about 3 months ago, in the context of the stated investigations of the European Commission. As you may know, back in 2014, the European Commission formally launched stated investigations against well-known multinational groups such as Amazon, FIAT, Starbucks, and Apple. By targeting these big names, the European Commission obviously wanted to address the widespread perception in the media that many multinational groups do not pay their fair amount of taxes. Well, not only certain multinational groups were targeted by these stated investigations, but also certain European jurisdictions, such as Luxembourg, the Netherlands, and also Ireland and Belgium. In order to set out the legal framework upon which this case law builds, we need to answer a basic question. What is state aid? The prohibition on state aids derives from Article 107, paragraph 1 of the Treaty on the Functioning of the European Union. We could say that we are in presence of state aid where we have an advantage granted to a taxpayer which is selective, then which does not apply to all taxpayers in the market, which is financed by budgetary resources, and which distorts competition. For the background in this case, back in 2012, the Luxembourg tax authorities and FIAT concluded an advance pricing agreement, or tax ruling, confirming the application of the arm's length principle to the following structure. We see on the structure chart FIAT Finance and Trade, FFT, a Luxembourg company of the FIAT Automobile Group. The main purpose of this company was to provide treasury and financing services to other EU group companies by engaging with other actors on the financial markets, coordinating on consultancy services, providing short-term fundings, and so on. Luxembourg has traditionally been a preferred location for the management of financing activities, while, until 2010, there were no formal transfer pricing rules governing the tax treatment of financing activities. As from 2011, the transfer pricing aspects of financing activities have been governed by a circular, the 2011 circular, which was then replaced by another circular as from 2017. Under this transfer pricing regime, financing companies were required to derive an arm's length remuneration on their financing activities, which is mainly based on the equity at risk. Such remuneration should be determined via a transfer pricing study in line with the OECD transfer pricing guidelines. On this basis, FFT received a remuneration for the services provided to the group companies, and that remuneration was subject to tax in Luxembourg. The arm's length nature of this remuneration was determined based on a transfer pricing study using the transactional net margin method, TNMM, in line with Luxembourg tax laws and circulars that were applicable at the time, and based on the OECD transfer pricing guidelines as well. Such remuneration was thereafter confirmed by the Luxembourg Tax Administration in the 2012 tax ruling. However, in 2015, the European Commission considered that the advance pricing agreement that FIAT obtained from the Luxembourg Tax Administration were constitutive of state aid. Hence, the Commission has considered that the aids granted to FIAT had to be refunded, leading to an additional charge of approximately 30 million euros. The Commission considered as main issue in this case the methodology confirmed by the Luxembourg tax authorities in the advance pricing agreement, where the risk remuneration for FFT has been calculated on the basis of hypothetical regulatory capital as opposed to the accounting equity. Indeed, the remuneration in this case was computed based on an amount of equity at risk amounting to approximately 30 million euros when compared to approximately 300 million euros of booked equity, so 10 times more, which obviously would impact the remuneration left in Luxembourg. The Commission considered that this approach was not suitable for the case at hand and wrongfully resulted in a lower compensation for the services, and consequently in a reduced tax basis at the level of the FFT. The decision of the European Commission was then challenged by the Luxembourgish government in front of the General Court, which is the lower court of the EU. However, in September 2019, the General Court confirmed the position of the European Commission. Indeed, both the European Commission and the General Court considered that the whole booked equity of the company should have been remunerated, as opposed to the hypothetical regulatory capital only. The problem here is that the European Commission totally ignores the concept of equity at risk and expected loss, and this shows a lack of understanding of the transfer pricing concepts in general, but also on the comparability principles. Indeed, based on transfer pricing rules, when determining the remuneration on intragroup financing activities, the arm's length remuneration is typically determined on the amount of equity which is at risk, not on the overall amount of equity. Here, the Commission disregarded the guidance provided in the 2011 circular and called for an autonomous interpretation of the arm's length principle. By following this approach, the Commission and the General Court seem to be of the view that holding functions and treasury functions have to be split, because otherwise the equity allocated to the holding function would have to be remunerated as well in the context of the group financing activity. Without going into too much details on the argumentation of the parties or technical aspects of the method used, I would like to highlight what are the most important elements of the decision of the General Court. In the European Commission's view, by granting this tax ruling, Luxembourg granted a selective tax advantage to FIAT, because the tax ruling applied a methodology that deviates from the Luxembourg general corporate income tax system. In its decision, the General Court confirmed that, besides stating that Luxembourg used a wrong methodology, the European Commission also has the burden of proving that this different methodology also led to a selective advantage. In this respect, to determine if we are in presence of a selective advantage, the Commission has to apply a three-step analysis. The first step is to determine what is the base reference system, so what is the general tax regime, in this case Luxembourg. The second step is to determine if there is a deviation or derogation from this base reference system. The third one is if there is a justification for deviation from such system. The General Court was convinced by the reasoning of the European Commission that the methodology used deviates from the Luxembourg General Tax system. In this respect, the General Court allowed the European Commission to use its own set of transfer pricing rules, rules that do not have its basis in the Luxembourg General System or OECD transfer pricing guidance. These transfer pricing rules, described in the European Commission decision, are indeed unwritten rules known only to the European Commission. In our view, it is contradictory that the European Commission was allowed to use completely separate set of rules in order to show that the reference system, which is the Luxembourg tax rules, was not in line with the Luxembourg rules. For all these reasons, FIAT has appealed against this decision before the Court of Justice of the European Union, the highest court of the EU. In its judgment issued in November 2022, the European Court of Justice set aside the judgment under appeal and annulled the decision made by the European Commission. Indeed, it considered that the state aid decision of the European Commission must be annulled to the extent no selective advantage was granted. The Court further states that there was an error of law of the European Commission and of the General Court in determining the rules, the reference framework applicable under relevant national law, which necessarily invalidates the entire reasoning relating to the existence of a selective advantage. In other words, the European Commission does not have the right to disregard the Luxembourg transfer pricing rules and replace it with some kinds of European interpretation of the arm's length principle. The Court clarified that only the domestic tax law applicable in a member state must be considered to identify the reference system for taxation. This is relevant for both the assessment of the existence of an advantage and the question as to whether an advantage is selective in nature. The outcome of the European Court of Justice does not come as a surprise. The decision of the European Commission, as endorsed by the General Court, has been heavily criticized as it looked like the European Commission tried to harmonize the transfer pricing aspects within the European Union by creating its own EU arm's length principle, against the member states' will. The Commission used the state aid tool as a disguised way to create tax harmonization, which is difficult to reach by itself, as the treaty provides for the unanimity among member states. Bottom line, this decision is very welcome and contributes to legal certainty for both taxpayers and tax governments. Happy to further discuss this and answer your question in the Q&A session.
Thank you, Alexandre. After having reviewed now the conclusions of the FIAT case, we choose a second case for you today, only that this case is purely domestic, and it also illustrates you the importance of transfer pricing in purely domestic situations. There are countries that do not apply transfer pricing regulations for domestic situations and only apply them for cross-border transactions, but Luxembourg is quite precise on this. The transfer pricing regulations apply also to purely domestic situations. So here we have a quite interesting case law on the requalification of an interest-free loan for transfer pricing purposes that is dated from the 23rd of September last year, has been rendered by the administrative tribunal. So we do not have any information whether or not there is an appeal on this case, but an appeal would have been possible. Let's start with the facts, which are quite straightforward and which refer to a very standard Luxembourg debt fund structure, a very typical structure that I guess most of you are familiar with, whereby, and we see it here on the structure chart on the slide, a debt fund basically establishes the Luxembourg Topco, which establishes the Luxembourg Subco. The Topco is financed by the debt fund by a profit participating loan, a PPL. Topco funds Subco by an interest-free loan, and Subco is then investing into typically a portfolio of debt instruments. Topco and Subco enter into a fiscal unity whereby the profit and expenses of the two companies can be compensated for corporate income tax purposes and municipal business tax purposes. Meaning that in practice, the way this structure works is that the taxable interest income at the level of Subco can be offset by the deductible interest at the level of Topco. The reason of the interposition of an interest-free loan between Topco and Subco has to do with our participation exemption rules, because if Topco would finance Subco entirely by equity, then the PPL would be deemed to be economically linked to the exempt participation that Topco owns in Subco, and the interest under the PPL would no longer be deductible. So this is the typical debt fund structure that has been used in the last 15 years, I would say at least, by several players on the market, and which has never raised significant questioning from the tax authorities, who seem to accept this structure unless there were cases of abuse. Now, what are the specificities of the case at hand? Well, in the case at hand, we had a Cayman parent that established Topco. Topco established Subco. Keiko funded Topco with the PPL, and Topco funded the Subco with an interest-free loan, and Subco performed the investments. The difference is that the structure, which had been set up in 2016, did not apply for fiscal unity in 2016. On top of that, the interest-free loan was granted by Topco to Subco with a retroactive effect. The agreement was dated from December, while the funding took already place in April, I guess. Instead of having a fiscal unity, the taxpayer considered that the interest-free loan was not arm's length, given that there is no such thing as an interest-free loan between unrelated parties. Unrelated parties would always have some interest accruing on the loan or some other remuneration for the lender, and therefore they calculated what the notional interest should be under the arm's length principle. So they calculated a hypothetical interest that unrelated parties would have applied to the interest-free loan, so that Subco could, for tax purposes, only deduct this interest, and Topco would then recognize this interest, which would trigger the interest under the PPL. And by doing so, at the end of the day, the taxable interest of Subco would be offset by the notional interest that Subco would recognize, and Topco would offset the notional interest by the interest under the PPL, except for the arm's length profit margin. Very important in this case is the fact that this only applied for the year 2016, because in 2017 the companies applied for fiscal unity, which was granted, and so the notional interest deduction has been abandoned. What happened? Meanwhile, we are in 2019. The Luxembourg tax authorities that reviewed the tax returns, they challenged the notional interest deduction. They had as main argument a substance over form approach based on paragraph 11 of our tax adaptation law. They had a closer look at the terms and conditions of the interest-free loan, and they highlighted that several features were pointing towards an equity qualification rather than a debt qualification, notably a limited recourse feature, the fact that there were no guarantees, there was a conversion right at the option of the lender, the loan did not bear any interest, the funding made by Topco into Subco was done before the legal arrangement had been executed, and in 2017 the notional interest deduction was abandoned, which is again not an arm's length behavior of the parties, according to the tax authorities. Accordingly, what they concluded was that the interest-free loan should be requalified into equity. If it is equity, the question whether the notional interest is arm's length or not, being what is the amount of interest that could be deducted, is no longer at issue. Because if the interest-free loan is requalified into equity, there is no longer any discussion on interest, and there is no deduction possible, given that it is an equity instrument which tax-wise, as share capital or share premium, cannot be remunerated by a deductible expense for the company. On top of that, the Luxembourg tax authorities dismissed the transfer pricing documentation that had been prepared in order to determine the arm's length profit that needed to be realized, because it was based on a TNNM, transactional net margin method, instead of using a CAP method, which is the methodology that the tax authorities in Luxembourg favor for back-to-back financings. At the end of the day, this was a very unsuccessful outcome for the companies, given that the subco had taxable interest expense, but no taxable interest income, but no expense, and Topco might have taxable interest expense, deductible interest expense, but no taxable income. So at the end of the day, it results in a tax leakage for subco and carry forward losses for Topco that can most likely never be used. The taxpayer then took the case before court and argued that, first of all, the notional interest was very well justified, because under the arm's length principle, an interest-free loan is not what you could see on the market, so there must be, under Luxembourg tax laws, an adjustment to be done under Article 56 of the Luxembourg income tax law. They also challenged the application of paragraph 11 of the tax adaptation law, because the tax adaptation law, paragraph 11, refers basically to the beneficial ownership of an asset, but is not as such, according to the taxpayer, a general substance over form provision. And they concluded that the interest-free loan had to be considered as debt. Why? Well, they argued that there were several features, notably the obligation to reimburse the loan, except in case of a default. There was a fixed maturity of 8 years, although a typo in the agreement referring to 10 years was also present. There was an option for an early repayment for the borrower. There was no entitlements to liquidation proceeds to the lender. There is no stapling clause. The lender has no voting rights. And there is no conversion right for the borrower. And the taxpayer also argued that the qualification should not change only because there is no interest and in the presence of a subordination or a limited recourse feature, because these features alone are not strong enough to requalify an instrument. And on top of that, they argued that the debt to equity ratio was clearly justified. So the court, the tribunal, analyzed this case and it basically analyzed this in a two-step approach. They said the first question to be answered is whether the interest-free loan should qualify as debt or should qualify as equity. If it is a debt instrument indeed, then in a second stage, the transfer pricing elements and the absence and the correct amount of the notional interest, those questions can be asked. But if the instrument is not a debt instrument but an equity instrument, well then it is clear that there is no deduction, and there is even the question of a notional interest is not relevant anymore. So what did the tax authorities, the tribunal do? And now we are in 2022, which also shows you the length of the whole process, given that the structure had been put in place in 2016, and now for the outcome we are in 2022. So that's 6 years after the structure has been put in place. So what did the tribunal, the judges, decide? Surprisingly, they referred to a recent or an older case law of the Court of Appeal that was dated 26th of July 2017, which decided that a shareholder loan is a hidden capital contribution if the normal financing would have been a share capital increase, and it results from the circumstances that the form of the loan could only have been chosen for tax reasons. This is pretty much in line with the OECD transfer pricing guidance of 2020, and it results in the obligation to analyze the situation on a case-by-case basis. So each and every individual case has to be analyzed, and it's not only the features of the loan that have to be considered, but it's also the circumstances into which this loan has been granted that need to be analyzed. So the judges reminded the usual conditions for a loan to be treated as equity. They referred notably to the unusual conditions in which a loan is granted and which would approach the loan to a hidden capital contribution. They also look at the determination of the interest. How is the interest determined? One could think of, is it a fixed interest, is it a variable interest, and so on. Is it only interest when the company that has borrowed the funds has actually profits and is in a situation that it can pay the interest? What are the repayment modalities? What is the allocation of the proceeds to long-term immovables? Are there any guarantees? Is there a disproportion between the share capital and the debt in terms of quantum? What are the circumstances in which the loan has been granted? Does the lender have voting rights? Does the lender have a profit or risk participation? Is the lender entitled to liquidation proceeds? What about subordination? What is the maturity? Is it long? Is it short? Longer maturity tends towards an equity instrument. Are there any conversion rights or reimbursement in shares? And is there a stapling feature? Stapling meaning that the loan would be stapled to the shares and that the one cannot be transferred freely without the other one. So this is basically the conclusion of the court case of the Court of Appeal from 2017, on which the judges based their analysis. In concreto, in the case at hand, the judges concluded that the interest-free loan is actually a hidden capital contribution. Why? Well, there are different maturities. Because of the typo in the loan, 8 or 10 years is not really relevant, because there is anyway no obligation to reimburse given the limited recourse features. So the judges, they concluded that if you have a limited recourse feature, there is no fixed repayment obligation for the borrower, because if he has not the means to reimburse the loan, he is freed from his obligation. This, of course, could be challenged because it's not so straightforward, at least in our view. The other criteria that judges used was that the funds were not allocated, the funds were actually allocated to a long-term investment, long-term immovables, for which normally you would use an equity funding. The debt-to-equity ratio was, in the view of the court, extremely of the judges extremely high, because it's 90-10. There were no guarantees, there were no indemnities, pointing towards a non-arm's length character of the loan agreement. And there was a conversion right at the level of the lender, so the lender could have opted to convert the loan into equity, which again can be challenged because the lender being the shareholder, he has anyway, under Luxembourg corporate law, always this possibility. And finally, the loan agreement was concluded after the funding. So the judges concluded that the interest-free loan in the case at hand was actually a hidden capital contribution. What are the conclusions that we can take away from this case? Well, for the qualification into debt or equity of an interest-free loan, the judges refer on the previous case law of the Court of Appeal rather than reverting or to the OECD transfer pricing guidance on financial transactions from 2020, which has meanwhile been published. The criteria are slightly different, and it would have given the judges more flexibility in their judgment, but nonetheless they based their decision on the former case law and did not refer to the transfer pricing guidance of 2020. The second point that we can take away is it is a quite standard structure that has been used for several years in Luxembourg, and as far as we know, it has never been changed by the tax authorities to the extent there was no abuse. Here, the particularity was that there was a notional interest deduction, and it has to be mentioned that the tax authorities have increased their scrutiny on notional interest deductions. It also highlights, again, the importance to have an accurate transfer pricing documentation and also to have a proper legal documentation. And the two, of course, must be complementary and not contradictory. And from a corporate law perspective, the documentation should be there from the outset. So one should avoid a post-closing cleanup. I think that is it for my part. I would be pleased to answer questions if there are anything, and I pass on to Sophie again. Thank you.
Thank you, Alain. Thank you, Alexandre. So there is actually one question on the decision of the administrative tribunal. Can interest-free loans still be used?
I think that's a question indeed for me. What we recommend is to be extremely careful with interest-free loans. As previously said, interest-free loans are used a lot, and to our knowledge, they are generally not challenged by the tax authorities except in abusive cases. Nonetheless, what we recommend is to be extremely careful about interest-free loans. It has to be checked what are the conditions into where this loan has been granted, what were the intentions of the lender and of the borrower. So it's not only the document itself, but it is also the circumstances. That is what the OECD refers to the two-sided approach, that if you qualify an instrument, you have to look at the perspective both of the lender and the borrower. And then on top of that, the characteristics of the interest-free loan should be closely reviewed. The fact alone that the loan does not bear any interest is typically regarded by scholars as not sufficient to qualify the instrument as an equity instrument. But you need, of course, to look also on the other features of the loan in terms of maturity, in terms of stapling, in terms of subordination, fixed repayment dates, and so on. So what we recommend is if there is if the loan does not bear any interest, all the other criteria should nonetheless be fulfilled, because it is actually an exercise, a balancing exercise between the features. And given that case law seems to apply still the criteria of the 2017 case rendered by the Court of Appeal, and the OECD having published their guidelines on 2020 with slightly different criteria, we would recommend that the two sets are implemented when using an interest-free loan.
Thank you, Alain. I think we are a bit late now, so I would suggest that we take the question and answer in separate message. Well, I think it's time to close the session. I would like to thank our speakers and you for joining us today. And I invite you to join the other sessions of the week. So I remind you that tomorrow we have a very interesting session on recent developments that will impact the asset management industry, with a specific focus on Pillar 2 and the importance of the consolidation criteria. And then on Thursday we'll have a session on real estate fund structuring, with a focus on market update in investment countries. And finally on Friday we'll have a session dedicated to VAT topics and trends. All sessions are at 1 o'clock Luxembourg time. So thank you very much for your attention and have a good day.